And very briefly, just before I begin, I think it's important to address some of the comments from Deputy Murnan O'Connor in relation to what you called misinformation in relation to the disquiet around the sealing of the archives back in October, and the insinuation there that it was the opposition drumming up false information or misinformation, as you called it. But all you have to do is Google it, Deputy, and you'll find that those quotes, the disquiet from survivor groups, opposition and all of the general public, came from direct quotes from the Minister and his department about sealing the archives. And you can look at that on the gov.ie website. Look at the gov.ie website, Deputy. On the outset, I think it's worth noting that the group of people this bill refers to have endured a particularly nasty and dehumanising form of abuse from the state, and that continues to a certain extent to this day. Forced family separation, along with practices of illegal adoption, the falsification of records, and the imposition of secrecy onto women and children. The state, as well as religious organisations and others, denied individuals their identity. It assaulted their sense of belonging and personhood from the day they were born, and subsequently did everything possible to oppose their access to information, including approaches that dismissed rights, infantilised survivors and further traumatised them. The parents, especially and most often mothers, were equally impacted by this regime. Disgracefully, this impulse from the state is still present to a certain extent. This legislation contains elements of it. A bill which has been deemed necessary despite the existing right to access one's personal information. I think it also should be noted that while these issues relate to mother and baby homes, there are many people affected who didn't go through that system. AINTIS, the Adoptee Identity Rights Advocacy Group, have highlighted many of the people they represent couldn't participate in the Mother and Baby Homes Commission, and they were not included in the Taoiseach's apology last year, a fact that needs to be rectified just as part of this process, I think. We need to officially and fully acknowledge the wrongs intentionally perpetuated against these adopted people and their families by the state. While any improvement on the state's refusal to provide people with their birth and early life information is welcome, this bill, despite months of engagement and recommendations from advocacy groups, does fall short of what is required and fails survivors in many aspects. It's deeply insulting and wrong that the rights of this group of people are not being fully vindicated when we have this opportunity. The pre-legislative scrutiny was extensive and detailed, with almost 40 witnesses appearing before the committee, survivor groups, advocates and human rights experts, as well as written submissions received. We carefully reviewed all submissions with the assistance of the Secretariat, when the Children's Committee did incredible work, and the Chair of the Committee, Deputy Kathleen Funchion. Our report synthesised all of those engagements into 83 recommendations, and disgracefully, a lot of them seem to be disregarded. I'm left wondering, what was the point of the pre-legislative scrutiny? Why did individuals and groups have to make another submission to share their story again, only for it to be ignored in many instances again? The committee report was published on the 14th of December. On January 12th, the bill was published. That's just 14 working days, not to mention the kind of Christmas disruption. So how much consideration was actually given to the recommendations from the committee? This isn't about the committee, it's about the voices of survivors and their advocates. All of our recommendations are based on their submissions. You're not dismissing the committee necessarily, you're dismissing them. There are several of the main issues that I wish to raise today. So firstly, and many other deputies have raised it, is the mandatory information session. The committee report was unambiguous. The mandatory information session should be removed from the legislation. An alternative appropriate safeguard should instead be provided, such as the sending of correspondence by registered post. The Irish Human Rights and Equality Commission stated that the information session presented an obstacle and potentially a complete barrier to individuals accessing long-sought information. The Council of Irish Adoption Agency described it as contradictory to the spirit of the bill. Others classified it as insulting, discriminatory and restrictive. While the Minister has changed the format of the mandatory information session, it is still an obstacle to accessing information. Many witnesses suggested alternatives, which the committee highlighted. They wanted to be proactive. However, the Minister and his department are seemingly unwilling to consider these. If this is about balancing privacy and identity rights, there are numerous ways to outline that to the individuals concerned. Forcing a verbal interaction with an agent of the state to outline what is already known is deeply problematic and potentially traumatic. But you're basically saying that's okay because there may be some counselling available. Moreover, Section 17 actually states that a purpose of the mandatory information session is to inform the adopted person of the importance of the relevant person respecting the privacy rights of the parent and the preference of the parent not to be contacted. That is an incredibly condescending and paternalistic statement to have written into law, reflecting how the state still views adopted people. This session remains deeply insulting, discriminatory and restrictive. Those affected are the people most aware of privacy rights. They have had a lifetime of negotiating these matters and they don't need you to explain it to them. Ultimately, this session is part of a false narrative that pits adopted people against parents. The implication of adopted people trying to track down parents was strongly contested in the committee. Our report shows that a small minority of mothers have expressed a no-contact preference, roughly 5%, while far more adopted people on the register have indicated that they don't want contact. This bill treats categories of affected people differently. The mandatory information session, which should not be in place, only applies to adopted people, not to parents. And it remains predicated on the concept that it is only parents who have a non-contact preference, and that is more common than it actually is. Unfortunately, this seems to be a case of the system protecting itself. The reality is that secrecy was imposed by the state agencies and religious orders on both adopted people and parents. The twisted morality of the time imposed social stigma on adoption and then engaged in the falsification of records. Since then, government departments, public bodies and religious orders have tried to maintain that secrecy. We can see all the remnants of this type of thinking in the very fabric of the bill and the implications on which it is based. The mandatory information session and all it represents must be removed from the bill. An alternative measure should be adopted, one which treats all relevant people with the same and with respect. And Minister, in your opening statements when you spoke about it being landmark and gave different examples of all these old bills and referencing that, quote, it doesn't criminalise adopted people. I mean, like, what kind of a low bar is that? To not criminalise adopted people? I can tell you what kind of a low bar it is. It's so low that it just shouldn't be referenced. It's not worth referencing unless it's in a completely different context to this one. Secondly, early life and care information. The committee heard extensive discussions on the need for broader understanding of care and early life information. It was recommended that the scope and extent of care information provided should be increased and that all information is part of an adopted person's history and heritage and must be included in the records provided to them. The prescriptive definitions in the bill, while an improvement on the initial schedule, is still limiting and does not guarantee access to the full range of potential care information, early life information and medical information. The Human Rights and Equality Commission warned that using restricted definitions will have a significant impact on the type of information that is available and those who can access it. The bill's definition of care information is linked to the limited list of institutions identified in Schedule 1. This confines the bill's application to just 44 institutions out of 182 known institutions. Agencies and individuals that were involved with forced family separation. The committee has a very clear recommendation here, which has again been disregarded. We sought that the list of institutions in Schedule 1 should be expanded to incorporate the full list of known institutions, agencies and individuals that were involved with forced family separation in Ireland, without limiting the bill solely to these bodies. While there is a provision for the Minister to add institutions to those outlined in the schedule, it's not only nonsensical to exclude them, it is indicative of an approach that is putting obstacles in the way of individuals seeking access to the information. That they'd have to seek your discretion when there should be no need is just ridiculous. Thirdly, terminology around adoptions. The bill clings to the euphemism of incorrect birth registrations as if they are not part of a system of forced family separation, as if it was a benign mistake rather than a multi-generational strategy by state institutions and religious orders to cover up illegalities. Let's be very clear, this was not incorrect birth registrations, it was the intentional falsification of birth certifications and other documents. It was illegal adoptions. The very least this legislation should do is be honest and name these practices for what they were and for what we all know they were. In the 2015 report on the pre-legislative scrutiny of the Adoption, Information and Tracing Bill, the Committee on Health and Children said that references to wrongful registrations or incorrect registrations suggest an administrative oversight and do not adequately reflect the covert nature of many adoptions carried out in the past. The committee further notes that there are no references or acknowledgements of illegal adoptions in the bill. Again, in this bill, the Department of Government could not bring themselves to even acknowledge illegal adoptions. In their submission, the CLAN project provides a definition of illegal adoption that should be in the bill as a more accurate and truthful alternative to incorrect birth registrations. On this point, the committee recommended that the bill should say falsely or incorrectly recorded birth registration, another recommendation by the committee ignored. Next, GDPR. Discussions of GDPR and the government's conservative interpretations of it permeated the pre-legislative scrutiny. This is an area of considerable complexity, but nonetheless, the committee were forced to recommend that the bill must be proofed to ensure that adopted persons are provided with a clear means of accessing their information in compliance with GDPR requirements. It is already clear that there are multiple issues with the bill and GDPR. GDPR itself already defines personal data as any information relating to an identified or identifiable natural person or data subject. The definitions in the bill do not align with that, and it is not permissible to limit the definition of personal data more narrowly than it is defined in GDPR. Several witnesses identified issues with state institutions and agencies deeming mixed information as third-party data rather than mixed data. The state's position leads to Section 62, which restricts individuals' rights under GDPR, and that is very worrying. It should also be noted that the phrase mixed data does not exist in the GDPR itself, and where data relates to two people, it is personal data to both of them and should be released. Section 16 introduces the insulting and simply wrong provision that family medical history is only provided through a medical practitioner. This new barrier is currently being used by the Department in relation to subject data access requests from Mother and Baby Homes Commission archives. Now it is extending it to adopted people and parents. Also, under our GDPR recommendations, the committee again calls for the removal of the mandatory information session as a clear barrier to individuals' effective right of access to information. These are only some examples. Initial readings of the bill by data experts and advocacy groups have raised serious concerns, which they warn could lead to massive confusion, a large number of complaints to the Data Protection Commission and litigation. These issues need to be rectified by the time the bill reaches the next stage.